A very good day to my lecturer and viewers. My name is Zulaika binti Muhammad Balij Karim Ablij of T1 Tutorial, and I will be presenting regarding the subject of Contract Law 1. To properly understand how to answer a contract law question, we must first understand the brief facts of the case. In this case, Adam promised to pay his nephew, Suhaimin, an amount of 500,000 ringgit as an incentive to marry his business competitor's daughter, Sri Dewin. However, unbeknownst to Adam, Suhaimin had been secretly engaged to Sri Dewin for months, and their wedding plans were well underway, with a date set for just in 5 months' time. In adherence to his promise, Adam displayed unwavering commitment by purchasing a Ford Mustang to Suhaimin as a wedding gift and formalized his intention to be legally bound by signing an agreement with Suhaimin. Subsequently, Suhaimin had requested that Adam sponsor his younger sister, Yuna, with a scholarship to pursue her studies in France for 4 years. At the time, Yuna was only 16 years old and excited about the prospect of studying abroad. Adam had consented to the request, explicitly stating that Yuna would be contractually obligated to work with his company for at least 5 years upon completing her studies. Both parties entered into an agreement outlining these terms, with Suhaimin acting as her guardian and signing on her behalf to validate the arrangement. However, Adam's business encountered severe financial distress, coinciding with Suhaimin and Suri Dewin's wedding. As a result, Adam reclaimed the Ford Mustang and failed to pay the 500,000 ringgit he had promised. Yuna was disheartened by Adam's actions towards her brother and initiated legal actions against Adam, alleging that he had failed to honor the promises made to Suhaimin. Furthermore, after the completion of her studies in France, Yuna decided to remain and work there permanently, refusing to fulfill her contractual obligation with Adam's company, citing concerns about his financial instability. Now that we understand the brief facts of the case, let's look into the issues. There are four issues in this question. The first issue being whether there is an existence of a legally binding agreement between Adam and Suhaimin in regards to the payment of 500,000 ringgit. The second issue is whether Adam was justified in reclaiming the Ford Mustang he had gifted Suhaimin as a wedding gift. The third issue is whether Yuna is able to initiate legal action against Adam on behalf of Suhaimin when Suhaimin was the person behind the signing of the contract. And lastly, the fourth issue is whether Yuna's decision to remain abroad and refusal to honor the agreement with Adam's company constitute to a breach of contract. Let's discuss on the first issue, which questions whether there is an existence of a legally binding agreement between Adam and Suhaimin in regards to the payment of 500,000 ringgit. Section 10, subsection 1 of Contracts Act 1950 states that all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration with a lawful object. Now, this applies to this question as the agreement between Adam and his nephew, Suhaimin, to marry his business competitor's daughter, Suri Dewin, constitutes a contract. Adam clearly expressed his intention to enter into the agreement by gifting Suhaimin a Ford Mustang as a wedding gift. Under the terms of the agreement, Adam promised 500,000 ringgit to Suhaimin if he married Suri Dewin. The 500,000 ringgit serves as a consideration, binding both parties, with Suhaimin obligated to marry Suri Dewin in exchange. As per Section 2, subsection D of the Contracts Act 1950, when at the desire of the promiser, the promisee, or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. In this instance, Suhaimin had agreed to marry Suri Dewin, the daughter of Adam's business rival, as a means of strengthening alliances and securing a beneficial position. In exchange for this commitment, Adam pledged to provide Suhaimin with a sum of 500,000 ringgit. The consideration from Suhaimin's side involves fulfilling his promise to marry Suri Dewin, while Adam's consideration is the payment of 500,000 ringgit to Suhaimin. As a result, Adam is legally obligated to fulfill the agreement by paying Suhaimin the promised 500,000 ringgit, as this arrangement constitutes a valid contract between the two parties. A relevant case to this issue is the Wong Hon Leong David and Nur Azman bin Adnan case. The brief facts of this case is that the appellant was the proprietor of a piece of agricultural land located in Kajang and desired to transform it into a housing development. The company required authorization from the government to convert and subdivide the land, so the appellant enlisted the assistance of the respondent, who asserted to have connections with the Mantari Basar. In exchange for his help, the appellant agreed to compensate the respondent with a sum of 268,888 ringgit. The respondent proceeded to draft a letter on behalf of the company to the Mantari Bazar and subsequently presented the appellant with a letter purportedly signed by the Mantari Bazar granting approval. A partial payment of 100,000 ringgit was made by the appellant. However, they refused to fulfill the remainder of the agreed upon amount. Consequently, the respondent initiated legal action on the grounds of breach of contract. The appellant contended that there was no valid agreement in place, as the respondent had not fulfilled any actual services. The issue of this case is whether there was a valid agreement between both parties and whether there was valid consideration governing the contract. It was held that the respondent promised to help obtain the approval of the Mantari Bazar, and the appellant promised to pay exchange of mutual considerations created a legally binding contract. Respondent used his connections to obtain the Mantari Bazar's support, which counted as valid consideration under the law. The appellant's intentions were clear by enlisting the help of the respondent. This applies to the case between Suhaimin and Adam. As in the case being discussed, Adam initiated the action by promising Suhaimin 500,000 ringgit as an incentive in exchange for marrying Suri Dewin. This demonstrates a mutual promise between both parties, with Suhaimin agreeing to marrying Suri Dewin and Adam agreeing to provide the incentive. This situation mirrors the case of Wong Hon Leong and Nur Azman Adnan, where a promise of 268,888 ringgit was made in return for help obtaining approval from the Mantari Basar. Despite the respondent sending the letter on behalf of the company, he still secured the approval as promised. The parties' intentions were clear, with the appellant seeking the respondent's connections to gain approval. In the case of Suhaimin and Adam, the fact that Suhaimin was already engaged to Sridewin does not nullify the contract, as they had not officially been married yet. The agreement stipulated that Suhaimin would receive 500,000 ringgit incentive upon marrying Sridewin. Adam's intention was evident, as he aimed to leverage the marriage for business advantage. The agreement between the parties is valid, and it is likely that Adam will fulfill the promise of paying 500,000 ringgit once Suhaimin marries Suri Dewin. In conclusion, it is probable that Adam is legally required to fulfill the 500,000 ringgit promise once Suhaimin has fulfilled his duty in marrying Suri Dewin. Providing fraud without clear evidence of deceptive intent may be challenging. Suhaimin has the option to take Adam to court for breaching their agreement. Now, let's discuss on issue number 2, which questioned whether Adam was justified in reclaiming the Ford Mustang he had gifted Suhaimin as a wedding gift. Section 26 of the Contracts Act 1950 specifies that a contract without consideration is invalid. However, it is mentioned that in illustration 1 that this section does not impact the validity of a gift between a donor and the recipient. The act cannot be classified as past consideration because it had not been completed. Therefore, there is no basis for compensation. Prior to this, Adam and Suhaimin had a pre-existing agreement in place, and the car was given as a gift to formalize this agreement. Adam solidified his commitment by executing a contract with Suhaimin, thereby reinforcing the notion of a deliberate intent to establish legal obligations. The transfer of the Mustang served as a gesture of fulfilling a promise made within the contractual framework. It is worth noting that gifts given as part of a contractual obligation remain bound by the stipulations outlined in the agreement. In conclusion, it is highly likely that Suhaimin does have the legal entitlement to take legal action against Adam for the reclaiming of the Ford Mustang unless Suhaimin explicitly permits the reclaimment of the Ford Mustang. According to cases like Kwang Kam Sun and Lian Sun Siu and others, formalizing arrangements in writing indicates a clear intent to be legally bound unilateral actions such as reclaiming a gift, once given as part of a binding contract, could be construed as a breach unless explicitly permitted by the agreement. Up next is issue number 3, which discusses whether Yuna is able to initiate legal action against Adam on behalf of Suhaimin when Suhaimin was the person behind the signing of the contract. In this instance, Yuna was not a party nor a privy or had any knowledge of the contents to the contract. The general principle states that only individuals directly implicated in the matter or possessing a unique relationship to it may pursue legal action or be subjected to legal action. The contract bounded both Adam and Suhaimin, with Suhaimin expected to receive the 500,000 ringgit promised by Adam in return for marrying Sri Dewin. Yuna lacked standing in this matter, as she was not a party to the original agreement between Suhaimin and Adam and did not have any specific ties to the case or potential benefits from it. Thus, only Suhaimin had the legal standing to pursue legal action against Adam for his breach of contract, while Yuna does not meet the criteria for initiating legal proceedings given her lack of involvement in the initial agreement between Suhaimin and Adam. The legal doctrine set forth in Tweedle and Atkinson case dictates that only the party who receives a benefit and gives consideration can enforce an agreement. In this instance, Yuna did not receive any benefit from the agreement and did not provide consideration. Even though she is Suhaimin's younger sister and could potentially benefit from her family receiving the promised 500,000 ringgit from Adam, Yuna did not contribute in any way to the agreement. As a result, she lacks the legal standing to pursue any legal action against Adam for breach of contract. The legal case of Kapung Prospecting and Schmidt serves as a clear example of how the Contracts Act dictates that only parties who have given or received something of value in an agreement have the legal capacity to sue or be sued under it. Yuna, in this instance, did not give or receive anything of value in the agreement. Conversely, Suhaimin promised to marry Suridewin at Adam's request, with Adam agreeing to pay 500,000 ringgit in return. As such, only Suhaimin is entitled to bring legal action against Adam if he chooses to do so. It is therefore unlikely that Yuna's legal action against Adam will be successful, as she lacks the necessary legal standing to initiate proceedings in court. In conclusion, it is determined that Yuna lacks the legal capacity to bring forth a lawsuit against Adam on behalf of Suhaimin due to the constraints imposed by relevant legal precedents and the doctrine of privity. Yuna's lack of involvement in the case, including the absence of consideration, exchange, or direct benefits received, precludes her from seeking legal recourse against Adam, even in the representation of Suhaimin. Suhaimin is the sole individual with the requisite legal standing to pursue legal action against Adam, should he opt to do so. The last issue of this case is whether Yuna's decision to remain abroad and refusal to honor the agreement with Adam's company constitutes a breach of contract. In this instance, the agreement between Adam and Suhaimin acting as the lawful guardian of Yuna does indeed form a scholarship agreement, given that Adam offered a scholarship specifically for Yuna's education and development. Both parties provided valid consideration, with Yuna being obligated to work for Adam for a minimum of 5 years after finishing her studies in exchange for the scholarship funding. With reference to the case of Government of Malaysia and Gurcharan Singh, it was established that even though at the time of entering into contract, Yuna was only 16 years old, which rendered her a minor, the court held in the aforementioned case that the education and training of becoming a teacher was under necessities, therefore rendered it a valid contract. Similarly, the current case involving Adam, Suhaimin, and Yuna pertains to a scholarship agreement for Yuna's educational pursuit in France, which falls under the category of necessity. Section 57, subsection 2 of the Contracts Act states that a contract to perform an act that later becomes impossible or is void due to an unforeseen event will be considered void once that act becomes impossible. In conclusion, the scholarship agreement between Adam, Suhaimin as Yuna's guardian, and Yuna is valid as contracts for education are considered necessities. Despite Yuna's status as a minor at the time of contract formation, legal precedents such as Government of Malaysia and Gurcharan Singh supports the enforceability of contracts for education or professional training as essential services. Yuna's refusal to fulfill the agreement and remain abroad constitutes a breach of contract, as she was obligated to work with Adam for a minimum of 5 years post completion of her studies. Adam has the right to pursue legal action to recover the scholarship costs as he is a party to the contract and have suffered financial loss as a consequence of the breach.